The magistrate in the case against 8 bodyguards accused of assaulting motorists on the N1 highway has warned that nobody is above the law, especially those entrusted to enforce it.
The accused in the matter, who are part of the Deputy President Paul Mashatile's security detail, were filmed recently attacking and dragging motorists on a highway in Johannesburg. That incident sparked massive public outrage. The magistrate, Willem Els, today granted the men bail of 10,000 rand each.
The charges alleged against the applicants are serious, and a strong message needs to be sent out to those who occupy the same position as the applicants that they have a duty to respect the rules of the road, further that we are all equal before the law, including the person they referred to as number 2, whom they were protecting.
Meanwhile, the NPA still believes it has a strong case, despite expressing disappointment with the bail application.
Well, the test in these court proceedings is on a balance of probabilities. Hence, we requested the court to hear hearsay evidence, which is admissible in these proceedings. However, we do take the court's remarks in a positive light. Though as the state we were sitting with a predicament that information was made available that one of our witnesses received threats, and therefore it was incumbent on us to protect the witness and ensure that we enroll the matter, as the prerogative lies with the state. And the test the docket has passed is prospects of a successful prosecution. So yes, investigations are not yet concluded, but we were not going to wait for investigations to be concluded to enroll the matter, because already with what we have at hand, we believe that a court acting reasonably may return a verdict of guilt.
Still today, the NPA denied that it does not have enough evidence to successfully prosecute the 8 men.
The guiding factor in enrolling any matter is evidential material contained in the docket, whether it is sufficient enough to pass judicial muster. It has nothing to do with the pressure that is received from the public. Yes, in taking such a decision, we would obviously consider the interest of justice as well as the interest of society. However, the guiding factor will always remain evidential material contained in the docket.
Let's take that story further now. Bring in the Institute for Security Studies researcher Willem Els, who's joining us on News at Prime tonight. Good to see you once again, Willem. So the magistrate hearing the case today said in the bail application stage that the evidence by the state was weak, but as you were just hearing the NPA spokesperson saying not so, can we even make that determination at this very early stage in the legal process?
Yeah, we must just understand, good evening to you, we must just understand that this is just a bail application, so the magistrate that is presiding is just going to hear over the bail application. So she will not be the trial magistrate. So that said, there are 2 ways of working or investigating these type of cases. In the first place, you can arrest the people, got enough evidence, and then you can bring them before court, and then once they are before court, you can ask for postponement as an investigating officer to further investigate, or you can investigate the complete case and then bring the case to court. So because of the pressure that is on this case, because of the nature of the case and how public it was, we believe that there is tremendous pressure on the investigation officers as well as on the NPA to proceed with this case. But as the person just mentioned, this is by a long way not completed investigation. Is going to continue. They can continue to build the case, and this is just unfolding. It is not the final hearing that is happening now. It's only a bail hearing. On the other hand, we must also understand that public perception in this case is against the police. It's against the criminal justice system. We see that there's an outcry from the public that the police and the system is failing them to such an extent that there's not a lot of trust But that being said, we must also understand that this is an ideal opportunity for the criminal justice system to redeem themselves in the eyes of the public, to bring forward a very good, well-investigated case, and let's see what will happen when all the facts come to the court.
You speak of the erosion in the relationship, or of the relationship between the South African public and police, yes, based on this incident and many others where police have been found, in fact, to have been abusive or have overstepped. How dangerous a point would that be for a democracy as young as ours if the public continue to lose faith or trust in the police service?
It will be very serious. We must just understand that this case is not being investigated by the police. It's being investigated by IPID, that is supposed to be independent from the police, even though one of the shortcomings of that is that even IPID reports to the Minister of Police. That brings their independence a bit into question. But that being said, they are doing the investigation. We just hope that they will be afforded enough time to do the investigation, and that they will also be afforded all the resources necessary in order to do a thorough investigation to build the case, and that they will be guided by the prosecution in order to build a good case.
I want to go back to the issue of the strength of the case that the state has so far. One of the challenges at this stage is that the NPA has not been able to secure as a witness the individual who recorded the actual assault on the highway near Fourways. How big of a setback is that for the state if they're unable, let's say, when this goes to trial, to actually secure that witness?
Well, actually, as we mentioned earlier, this is ongoing. The investigation is ongoing. So there is pressure on them to locate this person. And at the end of the day, we believe with good investigation, they will be able to locate this person, and then they will be able to summon this person to come and testify. You can't just present evidence in court if it's not verified by the person who actually is responsible for recording it. So that being said, I don't think that is a major challenge. With good investigations, it will be possible. And also, I think it's a bit unfortunate that the magistrate mentioned the strength of the case at this stage. As we all know, it's still under investigation. They are still building the case, and we are sure that with the amount of pressure that is on the investigating officers and on the prosecution, we will end up with a very solid case.
We're showing the video now, Willem, once more to our viewers of what happened. It's not a long video. These men have been arrested. They're out on bail, yes. What does the court now have to do, given that we can see them, you can identify them from the video? Does the court now have to determine whether they indeed are guilty of assault, or does it simply confirm that, but decide whether or not the action they took was warranted, given that they claim that the motorists in the Polo were unruly and at some point were threatening the safety of the convoy?
Yeah, you must just understand, whenever you do investigate a case and you present it to court, the court will judge it based on the reasonable man. So the court will now have to decide whether these officers acted within their powers, and if they acted as a reasonable man. So that on the one hand will have to be proven, and that will be debated in court. But on the other hand, also, all the evidence will have to be verified. The investigating officers, as you mentioned, will have to locate the person who took the video. Then that video can be submitted as evidence. We see that the officers already placed themselves on the scene by means of their affidavits. So the identification parade will just be a semantic in this case, but it will strengthen the case if they want to go through that. So, whenever you investigate a case, you have to be systematic and you have to build the case until it is very strong to present it to court. And we believe that will be the case in this matter.
You mentioned the court looking at what is reasonable action in a situation. We have this video of the assault. We're likely to hear contradicting versions of what happened in the moments before. Were the people in this car interfering with the convoy or not? If they were, would the most reasonable thing not have been to simply arrest them?
Of course, remember, those officers, in the first place, even though they are close protectors of the number 2, as I mentioned, they, in the first place, police officers, and they took the oath as police officers. So in the first place, they could have arrested this person, and whenever you do arrest a person, there are certain protocols, there are certain procedures, and it has to be within the auspices of the law. So now the court will have to decide whether these people overstep their mandate. And another thing also, when they left the victims on the ground there, we believe that one was unconscious. That is just a no-go. Whenever something like that happens, whenever you arrest someone, or whether you deal with the public in a situation like this, and there is an injury like that, there is an onus on you as the police officer to see that medical attention is being given, etc., etc. So there we also see that they really did not live up to what they were supposed to.
Willem Els from the Institute for Security Studies. Good to speak to you. Thank you.